way of that. My friend seems to be making a submission that I should argue in my writ petitions. That is how they take the advantages and
Today, somebody before your lordship, just a minute, let us not enter into the merits of the case. Somebody
day
is
after
asking,
tomorrow it can be.
no, day after tomorrow not possible. Tell us next week any day. We have already on the hearing batches. It is better if you take in the first week of January.
If they are
We keep parties to their counsel.
otherwise not, may I seek indulgence to 20th or 21st.
January. Learned counsel, your name please, on whose behalf you are praying for time. Just mention in a slip, such and such appearing WB prays for time on the ground of ill health of arguing counsel. The other side has no objection. As agreed, list in the week commencing 20th of January, Mr. Vidyasagar.
Because I have a difficulty, I may not be available.
That's right. The vacations are coming. 20th January. Yes.
Bless.
Pass over.
I'm represented by Mr.
Yes, Mr. Ravi.
Your Lordships were pleased to pass an order on the 29th of October 2024, calling upon the respondents to produce proof that the notice under section 148 was indeed served on the petitioner. And the respondents having sought time again on 26/11/24, your Lordships, granted a final opportunity to produce the proof of service of notice.
Mr.
Till date, your Lords, I have not received any.
Mr. Murali, are you equipped with the proof?
My lord, your lordship, last time it was also explained to your lordship. We tried to trace out the postal evidence, my lord. It could not be traced, and there is no. At the moment, there is no other evidence other than what is stated in the counter affidavit.
Kindly read the order. Mr. Ravi, do you have the order dated 29/10 with you?
Yes, your Lordship.
I got.
Kindly read it.
On 8th of July 2024, Learned Standing Council prays for and granted 15 days time to file proof of service of notice issued under 148 of the Income Tax Act 1961 dated 30/3/2021. Today, Learned Junior Standing Council submits that tracking record of the said notice dated 30/3/21 could not be obtained from the Postal Department because tracking record has shelf life. Learned Senior Council submits that as per para number 3 of the counter, it was not the stand of the department that the said notice was sent by post. Even otherwise, no postal receipt for showing sending of the said communication was filed. Faced with this, the Learned Council for Revenue prays for and granted 2 weeks as a last chance to file proof of service, failing which the matter will be heard finally in motion stage itself.
So your argument is that notice itself is not received, served on you.
Yes, yes.
And what is under challenge is final order, OIO.
Yes.
You will set aside, you serve the notice and proceed, Mr.
But your Lordship may only say that serve the notice if it is within time today, because much time has passed.
No,
And of course, the time during the period of
time consumed before this court has to be deleted.
That of course I can't say no.
Yes, Mr. Murali Krishna.
My lord, the contention in there is also a rejoinder to the counter. What the contention of the petitioner, my lord, is his PAN number is linked with Aadhaar, and once the PAN number is linked with Aadhaar, the address for communication should have been Aadhaar, and it has not been done. That is the contention of the petitioner. The registered address.
Any material, any proof that you send the notice, any proof of service. If their categorical stand is that show cause notice was never served, you filed counter in rejoinder, they reiterated. So you have to satisfy the court that notices were indeed served.
because I tried for the postal acknowledgement, my lord. That is the reason I took time on the last occasion.
Maybe
We are not able to get that.
otherwise, there is no material to show that notice was served. We'll set it aside, permit you to serve, provide by excluding this period which was consumed in this litigation. And if law permits, proceed. Serve, issue,
Yes.
issue notice.
Your
proceed.
Lordship can clarify those two aspects.
Yes. Mr. Murali Krishna, please try to understand. Suppose somebody comes before us with a specific pleading that show cause notice or OIO is not served on me. Then it is on you to show that it was served either on through email or postal, any.
Through email, it was all the notices were served through the faceless assessment, my lord. They have followed the process of assessment, and they issued notices.
Show us some material. Please show us some material. Because if somebody has not received it, he can only plead that I have not received it. Proof is with you.
My lord,
There is no pleading in the counter also. My learned friend is
your lordship may look at my counter, my lord.
Counter. Which paragraph of your counter deals with service of notice?
That is para 4, my lord.
Yes.
Para 3, your lordship may start with para. It is submitted that notices were duly issued and served on the SSC, on the e-filing portal, and on the address registered by the SSC on the e-filing portal. As such, it is evident that the SSC was accorded sufficient time and opportunities in the form of multiple notices from time to time before passing the assessment order. Therefore, it is reiterated that the principles of natural justice were thoroughly complied with during the entire course of assessment proceedings. In view of this, the contention of the SSC that the assessment order was done in the absence of the petitioner is grossly unacceptable. It is submitted that the contention of the petitioner is that the notice
of the rejoinder. Mr. Murali Krishna, kindly come to para 6 of the rejoinder.
It is submitted that in view of the failure on the part of the SSC in responding to the said notices issued, the assessing officer proceeded with the completion of the assessment proceedings, relying on the information available on record. The assessing officer considered that the SSC to be the owner of money to the extent of rupees 2,23,48,925, which is deposited in the bank and also partly utilized for purchase of vehicle. The assessing officer treated the entire amount under section 69A. My lord, this is the now the
rejoinder. Kindly read Mr. Murali Krishna, para 6 of the rejoinder.
The averments made in counter 3, para 3 of the counter are denied. The respondents have contended that the notices were duly issued and served on the SSC through e-filing portal. Merely uploading the notices on the e-filing portal of the income tax department is not proper service as per section 282 of the Act.
Kindly come to section 282. This is one of the permissible mode. Because if I correctly remember, this was argued because the language used in the statute is delivering or transmitting. Section 282. If you are putting it on your portal, it is not delivering. Delivering can only be on his email address. Because the language is by delivering or transmitting a copy thereof to the person concerned.
Yeah, your lordship may see in the
person.
By delivering or transmitting a copy thereof to the person herein named.
Person therein.
It is when whatever the registered email address in the portal is sufficient, my lord. And there is also a procedure.
Where is your averment that you have sent it to the email address? You said that you have filed it, placed it on the portal, e-filing portal.
Yeah, exactly. He doesn't say that it was sent to the email address.
Kindly see your para 3 of the counter.
It is submitted that the notices were duly issued and served on the SSC, on the e-filing portal, and on the address registered by the SSC on the e-filing portal. Because the contention of the SSC, my lord, what my respectful submission, my lord, the contention of the SSC is, your lordship may look at the counter filed by the rejoinder filed by the petitioner, my lord.
Yes.
Para 4, my lord. As per the provisions of the Finance Act 2017, read with CBDT notification number 17 of 22 dated 29/3/22, linking of Aadhaar number with PAN number has become mandatory. And I submit that my Aadhaar number is linked with my PAN number. As the notices were not issued to the address mentioned in my Aadhaar, I could not file any reply or return against the notice under section 148. It is therefore denied that I failed to file the return of income in response to the notice under section 148, because this is now, he is in this petition, my lord, he is questioning the notice under section 148 after conclusion of the proceedings. And subsequent to the issue of the notices, there were several notices, several communications which have been made through the portal, my lord. He did not respond to any of those, and now he is questioning the service of 148, my lord. See, he can always question this on 148 in an appeal also, my lord. See, at this juncture, to really crash the entire proceedings based on 148 notice, he could have approached 148 at that time itself before participating in the proceedings. And after several notices, and after conclusion of the assessment proceedings, and then appeal order is served, and on that he has a remedy of appeal. Your lordship may kindly consider that he can always raise all these contentions before the first appellate authority and raise take the proceedings further, rather than trying to impose conditions on the department at this juncture on the service of notice, my lord. That is my respect.
Mr. Ravi, how do you deal with this argument that it was...
There are two things. One is the notice under section 147. The other is the notice under section 143(2). What the counter addresses, my lord, in the paragraph which my learned friend just showed to your lordships now, is not the notice under 147 at all. Your lordship may for a minute take the counter affidavit. In so far as the 147 notice is concerned, it is only dealt with in paragraph number 1 of the counter. If your lordships please come to page number 2, middle of that page. In addition, it was noted that the assessee has entered into a transaction of purchase, sale of motor vehicles costing so much. However, the assessee had not filed the income tax return of income for 2014-15. It is submitted that on the basis of the information available, the petitioner case was reopened for assessment year 2014-15 issue of notice under 148 on 30/3/21 under a reasonable belief that the income had escaped assessment. But insofar as this notice is concerned, there is no statement as to how it is sent. Para 2 begins with the 142(1) of the Act. He speaks about notices dated 12/11/21, 26/1/2022, and in that context, he mentions the email, etc.
And so tracking number was also mentioned.
Please do not interrupt. But insofar as the 148 notice is concerned, this is all the statement. And I specifically pointed out in my rejoinder that, my lords, that they have given an evasive answer. Please see para 3 of my rejoinder. Second page.
Yes.
It is noticed that even in the counter affidavit filed by the respondents, there is no whisper about services of notice under section 148 of the Act. And the respondents have failed to produce any evidence with regard to service of notice under section 148 of the Act. My learned friend is conveniently mixing up 142 notices with 148 notice. 148 is the precursor for everything. This is where it has to start. That notice itself is not served. And there is no, and all the while my learned friend has said that there is no evidence available with us at this point of time. Today, my lord, he is saying that we have served it.
Is there any interim protection prevailing in your favor, Mr.
No, my lord.
Ravi? Yes, your response is in relation to a different notice, Mr. Murli
Yes.
Krishna.
No, it is not. There is no, in fact, the service of 148 notice, because we could not trace even the tracking number
That's
of the
all.
148 notice, because that was served. And no, my lord, at this juncture, the subsequent notices have been served and they are in portal. And no, he doesn't respond to any of these notices. And without responding to any of the notices of the department, and now at this juncture to come before your lordship in a writ petition, and then question the entire proceedings, including the 148 notice, in my respectful submission, is not permissible.
Murli Krishna, whether everything begins with section 148 notice or not, the entire proceeding starts with 148 proceeding or not. That is the foundation of your all subsequent actions.
Exactly.
No, the 148 notice, without service of 148 notice, 142 will not be served, my lord. The only thing here, the only practical difficulty, my lord, is whether
if you are not able to substantiate that 148 notice was served on him, your entire building founded upon that notice will collapse.
The 148 notice at this juncture, we are not able to produce further evidence on that. It has been served, and because if your lordship look at the portal, 148 service of notices will also be recorded. But the only thing is actual proof of service we are not able to produce.
But you see the language it's employed in section 282 to the persons, that has to be transmitted and delivered to the person.
Because
Set aside that permit you to issue notice by excluding the time consumed before this court if limitation permits you.
lordship may see in the form of electronic record.
Has to be limitation should be.
We'll exclude the time which is consumed here. You can utilize that time for the purpose of limitation.
Then we are unable to come within the purview of the limitation, Milord. No. Assessment proceedings, time taken also should be excluded, Milord. Then only it will be within the limitation.
But it's that there is no ground for excluding that period of time. As a matter of fact, even without a stay, I'm conceding to the fact that period consumed in this honorable court may be excluded. My learned friend is now asking for an opportunity to serve the notice today as if nothing had happened on all this period.
Yes, anything else, Mr. Murli Krishna?
My lord, your lordship may see clause C in the form of any electronic record as provided in chapter 4 of the Information Technology Act 2000. That is also a permissible service.
You please tell us from information technology that portal can be one of the modes, one of the form.
Your lordship may give me a post-it of next week.
Lord, this matter has been adjourned umpteen times.
And I will address this issue, my lord. The matter has been adjourned on different grounds, and our lordship specifically pointed out a specific issue of service of notice. I will take instructions and try to.
We read out this also on the last day, last week, whenever this matter was listed.
Lord?
We will keep it tomorrow. Come prepared with this IT.
Tomorrow is because I need to contact the people concerned in Nizamabad.
People will do it.
It's a matter of law. I don't know why my learned friend should contact the father.
Sub-clause C is you have to take assistance from the Act. What your officers will do it. It is for you to apply your mind and tell us how it is covered by IT Act.
My lord, this is a matter which will have a lot of general importance, my lord. I need proper instructions, and your lordship may post it next week at your convenience.
We'll grant you interim protection and keep it in due course. We'll admit this petition. Like you say, as Ravi, senior counsel for the petitioner, such and such, heard petition is admitted for hearing, list in due course. Learned counsel for petitioner submits that without serving the notice under section 148 of IT Act, the respondent proceeded with the matter and passed the impugn order. Issuance and service of notice under section 148 is precursor of the entire proceedings. It is pointed out that despite directions issued by this court, the proof of service of notice has not been filed, and therefore adverse inference may be drawn against the department. Shri Murli Krishna prays for time to seek instructions regarding mode of service mentioned in section 282 of the IT Act. Prayer allowed. List in due course. Till next date of till further orders, no coercive action be taken against the petitioner pursuant to impugn order.
Oblige, Your Lordship.
Much obliged.
This matter needs to be heard, Your Lordship.
Yes, madam. 48, 49.
48, only 48.
Who appears for petitioner? 48. Pass over.
Your Lordship may have it tomorrow, Your Lordship.
What is the urgency? Any urgency?
They don't have an interim order, but because I have asked them to stay their hand, they've not taken any steps.
If she doesn't come in Passover, we will post it after vacation if there is no urgency.
If I have any difficulty, I may request my colleague to.
Anybody can appear.
Oblige.
Yes.
Your Lordship, I pay for R2, my lords. Counter is filed this morning, my lord.
You want to file counter?
I filed R1, I filed count. Already filed.
Already filed. Yes.
Auto counter is required.
R2, I filed this morning, my lords. It's been filed this morning.
I have not received copy.
He'll supply
We'll
copy.
serve in the meantime, my lords.
Like R1, counsel for R1 submits that counter has been filed today and copy will be
R2, my lords. I'm sorry, my lords. R2.
Copy will be supplied to petitioner during the course of the day. You supply copy.
Yes, my lords. We'll make sure.
Rejoinder, if any, may be filed within 2 weeks. List after January vacation.
Obliged, my lord.
Obliged.
Your Lordship, I'm appearing for the petitioner. The matter is coming up for filing of counters.
It's allocated to Mr. D. Raghavendra Rao here.
May it please Your Lordship, I'm appearing for the respondent, Your Lordship, D. Raghavendra Rao. We are newly appointed, Your Lordship, kindly requesting 2 weeks. Your
How much time you want?
2 weeks, Your Lordship.
2 weeks time to file counter, 2 weeks for rejoinder list thereafter.
Your Lordship's interim relief may be.
IR, if any, shall remain in office.
Obliged, Your Lordship.
Much, Your Lordship.
Wait, please, my lords. I appear on behalf of the petitioner in this matter. Lords, this is a matter where the petitioner has entered into 3 agreements of sale on 8/11/2021 for purchase of immovable property, my lords. The sale consideration as on the date of execution of the agreement of sale is 2 crore 40 lakhs. Subsequently, the sale dates were registered on 11/3/2022.
What is the relevance of 11/3/22?
My lords, I'll explain the relevance because I'm relying on section 56, subsection 2xb, where I'm protected by a provision if there is a difference in the value, market value of the property as on the date of agreement of sale and as on the date of registration of the property. And if the difference is, if I have not paid the sale consideration in advance, then the difference in value will be deemed to be my income under the Income Tax Act. But if I have already paid part of the sale consideration as on the date of agreement of sale, then even if the market value of the property is increased, that cannot be added as my deemed income. Now what has happened is, as on the date of agreement of sale, the market value of the property was increased to 2 crore 95 lakh 86,000.
Can you mention the amount again? 2 crore?
95 lakhs 86,000. So the difference between the amount in the agreement of sale and the value of the land, value of the property as on the date of registration is 55 lakh 86,000.
Yes.
On 31/12/2022, I have filed the returns. I have received an intimation that an amount of 27 lakh odd is the income tax payable in view of this additional amount that I have disclosed. I have also included this differential amount as my deemed income. Subsequently, I filed an application before the PCIT under 264 seeking revision of this by submitting the SRO value as on the date of execution of the, as on the date of entering the agreement of sale. My lords, may kindly see section 56 here.
Which order is troubling you? What is under challenge before?
Under challenge, now the PCIT has rejected my revision application on the ground that there is a delay in filing the application and I'm trying to take benefit of the SRO value.
Which is that order impugned?
My lords, that order is at page 18.
Your revision is not entertained on the ground of delay.
Yes, my lords. My lords, may kindly see page 20, para 8 and 9. Para 8 and 8.1. Para 8.
Yes.
I have perused the contentions of the assessee and the material available on record. The assessee has voluntarily admitted the amount of 55 lakh 86,000 being the difference between the registered sale deed value as per SRO and the actual sale consideration under the head income from other sources and paid taxes accordingly. The assessee claims that the relief benefit available to him has not been claimed at the time of filing the return on 31/12/2022 due to non-availability of SRO values. He further claimed that to avoid litigation and pay and levy of possible penalties, he disclosed the above deemed income and paid all the applicable taxes. It is pertinent to mention that the date of sale agreement was 8/11/2021, date of registration was 11/3/2022, and the date of filing of return is 31/12/2022. Assessee had an ample of time to claim the actual price in filing of return of income. The assessee is well aware of the rates prevailing on the date of agreement as well as on the date of registration. Now the assessee has come with an application under 264 just to get advantage of the reduction in the SRO value. The PCIT is not denying that I am not entitled to that benefit. The ground taken here is that there is a delay in approaching or obtaining the SRO value.
This is for refund.
Yes, my lords. This is for refund. Yes, my lords. In the computation of total income statement, the assessee himself voluntarily offered the difference income under 56/210 under the thought. The income offered while filing the it does not fall under the category of not claiming a legitimate claim. The facts of the case relied upon by the assessee are different from the facts of the assessee's case. In view of the above discussion, facts and circumstances of the case, the assessee's claim does not come under the purview of 264 of the Income Tax Act and hence dismissed. Lords, may kindly see section 56 of the Income Tax Act.
Which rate is relevant? Which is at the time of agreement or which is
at the time of agreement, my lords? That is clearly specified in the Act itself. If I have already paid the sale consideration as on the date of execution of agreement of sale, even if there is a subsequent increase in the value of the property, that will not be added as my deemed income.
Right, but the court, this authority says that you were aware of the rate as on that day.
As on the date of registration, we are aware, my lords, because at the time of registration of a agreement of a sale deed, the market value will be checked by the SRO. They will generally give it, especially if my agreement of sale contains a value which is lesser than the present stamp duty value as per the SRO, they'll give us a statement. We are aware of the statement, we are aware of the value as on the date of execution of the sale deed, the registration, which is in March. Whereas we did not have access to the value of the land as on the date of execution of the agreement of sale.
Where have you said so in your revision with your application which has been rejected?
Yes.
How did you explain this?
Lords, may kindly see para number 4 of the same revision. He records that I have submitted the statement as well. Para 4 at page 19.
Yes.
The assessee further claims that the SRO value as on the date of agreement 8/11 was 1 crore 65 lakh 9,000 odd, whereas the same as on the date of sale deed was 2 crore 95 86. However, the assessee claims that the said property was purchased actually for 2 crore 40 lakhs. The assessee claims that he paid the entire amounts of consideration by the time of entering the agreement. As in the date of agreement, the SRO value was only 1 crore 65 lakhs, whereas it was agreed to purchase for 2 crore 40 and accordingly paid the amounts. In proof of his claim, the assessee furnished copies of the Annexure 2 issued by the SRO to confirm the SRO values prevailing as on the date of agreement and date of registration. So the
But where have you said that you were not aware or you came to know about these annexures when you preferred the return, when you
My
filed
lords, the
the
revision
return?
application filed before the PCIT is at Annexure P6 starts at page 70, my lords.
Because he is treating it to be an afterthought. No, he has used that language also.
Yes, my lords. I'll explain that as well. Even if he's terming it as an afterthought, if the Income Tax Act gives me this benefit, the PCIT ought to have applied his mind and adjudicated whether or not I'm liable to pay the tax.
Madam, the basic question is, you are not doubting the genuineness of the rate which he is filing with this.
Yes.
If he is in a position to show that that was the SRO value, the section will operate.
Lord, in fact, they're covered under 50C, my lord. They themselves have paid the amount after the intimation order was passed. My lord, the intimation, my lord, under section 143 was dated 31/12. And they have paid the amount of 27 lakhs and odd, my lord, and 27/1 accepting the intimation. My lord, against the intimation, if they were agreed, my lord, they could have filed an appeal under before the CIT
That
appeals.
is not the reason for rejection.
No, my lord. Here, my lord, they're covered under 50C. Your lordship may look into the provision of 50C. Even under 56, my lord, wherein they're claiming under 56
They have
2X.
preferred an application for refund. It is rejected on a particular ground.
Yes.
So validity has to be seen on that ground. You have not rejected that this remedy is inappropriate.
Yes,
You should go to another remedy. Law is so well settled that validity of an order of statutory authority is to be seen on the grounds mentioned therein.
Yes.
Constitution bench, Mohinder Singh Gill.
But here, my lord, the provision which they seek that they're coming under, my lord, is not applicable to them.
But that is not the reason assigned by you.
My lords, if I may also clarify on that provision, my lords, may kindly see 56 once, my lords. 56 of the Income Tax Act.
Yes.
56 subsection 2, my lords. In particular and without prejudice to the generality of the provisions under subsection 1, the following income shall be chargeable to income tax under the head income from other sources, namely 10, my lords. Subsection 10.
This is Roman 10.
Roman 10, my lords.
Roman 10.
Roman 10. Where any person receives.
Just.
Where any person receives in. Yes, my lords.
Yes.
Where any person receives in any previous year from any person or persons on or after 1st day of April 2017, A, B, I fall under B, my lords, any immovable property without consideration, the stamp duty value which exceeds 50,000 rupees, the stamp duty value of such property, for a consideration, the stamp duty value of such property as exceeds such consideration if the amount of such excess is more than the higher of the following amounts, namely, amount of 50,000 rupees and the amount equal to 10% of the consideration, provided that where the date of agreement fixing the amount of consideration for the transfer of immovable property and the date of registration are not the same, the stamp duty value on the date of agreement may be taken for the purpose of this subclause. I'll get this benefit only as per the second proviso, my lords. Provided further that the provisions of the first proviso shall apply only in a case where the amount of consideration referred to therein or a part thereof has been paid by way of an account paycheck or an account pay bank draft or by use of electronic clearing system through a bank account on or before the date of agreement for transfer of such immovable property. In my case, I have already paid the agreement, the sale consideration as on the date of agreement of sale. So this is a benefit that I get. There is no provision under the Income Tax Act by which the PCIT or the Income Tax Department can add this differential amount to be my deemed income.
And this application was filed under which provision?
264, my lords. 264.
Let us see the scope of 264 also.
Yes, my lords.
It's a kind of review. Revision. Because their principal reason for rejecting is that when they
What's the
that in
limited
the,
issue
in the,
here is
in
this.
the return you have not claimed anything and
Paid the amount later on 27 1 my lord, and later on came up with a claim that
This
it
is
was
the
a
differential.
wrong omission.
My lords, here the limited issue is the
In
power
fact, it is
of
covered in my
PCIT.
counter as well, my lord.
Now the PCIT is saying that I have voluntarily offered this income. Whether
Yes.
or not it is leviable under the income tax is not a
Your
question.
lordship may look
Since
into
I
it.
have voluntarily offered this income, I have to be taxed for this. Now the limited question here is of the power of the PCIT under 264. My lords, previously I have relied on the judgment, Delhi High Court Division Bench judgment in Vijay Gupta versus Commissioner of Income Tax. I'll pass on copies of the judgments again, my lords.
because they say that you yourself voluntarily offered the difference
Yes, my
income.
lords.
Yes, your lordship, that is
clarify-
evident
I'll
from the
clarify about that,
intimation,
my
my lord.
lords. My lords, may kindly see paragraph number 35. It's the last second page, my lords.
Yes.
From the various judicial pronouncements, it is settled that the powers conferred under section 264 of the Act are very wide. The commissioner is bound to apply his mind to the question whether the petitioner was taxable on that income. Since section 264 uses the expression any order, it would imply that the section does not limit the power to correct errors committed by the subordinate authorities, but could even be exercised where errors are committed by the assessees. It would even cover situations where the assessee, because of an error, has not put forth a legitimate claim at the time of filing the return, and the error is subsequently discovered and is raised for the first time in an application under section 264. An assessee is liable to tax upon only such receipt as can be included in his total income and is assessable under the Income Tax Act. There is nothing in section 264 which places any restriction on the commissioner's revisional power to give relief to the assessee in a case where the assessee detracts mistakes because of which he was overassessed after the assessment was completed. Once it is found that there was a mistake in making an assessment, the commissioner had power to correct it under 264(1). When the substantive law confers a benefit on the assessee under a statute, it cannot be taken away by the adjudicatory authority on mere technicalities. It is settled proposition of law that no tax can be levied or recovered without authority of law. Article 265 of the Constitution of India and Section 114 of the state, this is not also, imposes an embargo on the imposition and collection of tax if the same is without any authority in law.
In
That
fact, my
covers
lord,
mistake of assessee also. not
yes,
only-
my lord, let me
Assessment.
portray, my lord. Your lordship may look into the intimation, my lord, which was passed on 143(1), my lord, which is at page number 65. They themselves have come along with the income under other sources, my lord, which says 56 lakhs. Then again, my lord, under the intimation, and when there was a demand, my lord, on 31/12, they have voluntarily paid. They have voluntarily paid an amount of 27(1).
That may be an error on their
Yes,
part.
my lord, your lordship. They are covered under section 50C, my lord, wherein the special provisions, your lordship may look into 50C for a moment. (50C), my lord. Your lordship has got it, my lord?
You are talking about a different remedy.
Wherein, my lord, when there is a difference between the market value taken with the date of agreement and the SRO value, the SRO value has to be considered. Wherein the petitioner states, my lord, the time of the agreement of sale has to be considered is the section which is relied by the petitioner.
But that is not the reason for rejection.
Not here. There was an
Singular-
increase in the
singular-
SRO value. Your lordship will look into the dates and the amounts, my lord.
Your singular reason for rejection is that when she,
The similar reason for rejection was that the SRO value which ought to have been taken, they have taken 13
can
months
you
to
read
get the valuation.
Can you read the conclusion portion, the
Yes,
operative
my lord.
portion of the impugn order?
It's from para 8, my lord.
Let's system.
Your lordship may permit me to read from para 5.
Did you file the yet? It's not opening. Page number?
Page number 19, my lord. Para 3 and para 4 state about the SRO value and the date of agreements. If your lordship may permit, I'll read it from there.
First, kindly come to 8.1.
Yes.
Dates are mentioned here also. Sale agreement was?
Yes, my lord. The sale agreement was on 8/11/21. Date of registration was the 11/3/22. And the date of filing of return is 31/12/22.
Yes.
Assessee had an ample time to claim the actual price in return of income, filing of return of income. The assessee is well aware of the rates prevailing on the date of agreement as well as on the date of registration. Now the assessee has come with an application under section 264 got to get the advantage of the reduction in SRO values. In the computation of total income statement, the assessee himself voluntarily offered the difference income under section 56(2)(x) under the head income from other sources. And the present claim is clearly thus just an afterthought. The income offered while filing the return is not a mistake, script or an error. It also does not fall under the category for not claiming a legitimate claim. The facts of the case laws relied upon the assessee are different from the facts of the assessee's case. View of the above discussions.
The finding is that it's an afterthought to get advantage of reduction of SRO values.
Yes, my lord.
From where he is getting this benefit. This finding is based on what? Because he has filed the relevant schedule.
Yes.
That is at paragraph 4.
Yes, my lord.
He has filed the relevant annexure issued by the SRO to confirm the SRO values. From where your authority is getting that he is relying on a different, SRO value which is reduced on a reduced amount. Can you see the finding? It's an afterthought because the reduction of the advantage of
8.1 has to be read along with para 8, my lord. Para 8, my lord,
Yes,
very
can you
clear.
read para 8?
Yes, my lord.
Can
I
you
have
read para
perused
8?
the contentions of the assessee and the material available on record. The assessee has voluntarily admitted an amount of so and so being the difference between the registered sale value, deed value as per the SRO and the actual sale consideration. That is 295.86 minus 2 crores 40 lakhs. Under the head income from other sources and paid taxes accordingly. The assessee claims that the relief benefit available to him has not been claimed at the time of filing of the return on 31/12 due to non-availability of the SRO. Here, my lord, I would pause. Here, exactly, my lord, few minutes back, the petitioner herself has claimed that they have taken the valuation of the date of agreement. But, my lord, what we state is we are relying on the sale deed, my lord. Usually, when they go for a sale deed, my lord, when they're going for the registration, the valuation which is at the SRO will be considered, and it will be deemed on that.
You could have rejected by saying so. You have not rejected on that ground. You have refused to undertake the exercise of revision itself by saying it is an afterthought. You can say that for XYZ reason this is not applicable, this is applicable. But no adjudication has taken place on revision.
Lord, personal hearing was given, they have
an afterthought.
Personal hearing was given, my lord, only after due opportunity was given, this was decided, my lord.
Right, but where is the adjudication that
Lord, adjudication and so far that is concerned. Your lordship may further, let me
see
read.
the finding.
He
Just
further
to
claimed.
get advantage of reduction in SRO value, then you should have mentioned that the SRO value on which he is placing reliance came subsequently, not prevailing at the time of agreement of sale.
Lord, here, my lord, it says, my lord, the assessment records were called for and they were posted for hearing and they were heard. The said reason which they claim right now that they could have adjudicated the same even before the authority.
If you read 8.1 carefully, principally two reasons. Number one, that on when he disclosed the income in the return, it is not meant. Mistake, error committed by the assessee can also form part of a revision exercise. Second is that it is an afterthought to take advantage of reduction in SRO value. Afterthought means some SRO value came later, after this date of agreement to sale, and they are taking advantage of it. No dates are mentioned, no source is mentioned. From where you came that reduction of SRO values.
Lord, in fact, even in the application, they have given it so, my lord, but the application of mine
We will remand it to decide it on merits. And you relied this Delhi High Court before?
Yes, my lords, they say that the facts are different.
It's only
Although the
insofar
facts
as the
are different in
264
this
is
case,
concerned,
the
my
law
lord.
regarding the revisional power under 264
No,
is the
that this
same.
very same judgment was
Very
cited.
same judgment was cited, my lords. It's part of the record.
Your lordship, may permit me to read 50C, my lord, for a second.
Madam, we will examine the validity of an order on the grounds mentioned therein. You have not rejected on that ground.
Yes, my lords.
Maybe
There may
remanded,
be
my lord,
100
if you,
good
I leave
grounds
it to
for
your
you to
lords, my lord.
reject.
Your lordship may fix a date and a particular
Yes, we'll
hearing, my
fix a
lord. They may
date.
appear without any further notice and it will be decided, my lord.
Fix a date, we'll remand it back to.
Definitely. My lords,
Any
may-
particular objections may be taken at one point itself, my lord.
Yes, filed the annexure. Yes, filed, I've seen it.
Every objection, my lord, they can be taken at the time of, before hearing, my lord, so that they can be heard on all the objections.
You provide a rehearing,
No.
they'll raise all
They can
possible-
appear on a particular mentioned date, my
We'll
lord.
fix a date
Yes,
from here.
yes.
My lords, if I only request one thing, my lords, since the market value as on the date of agreement of sale and as on the date of registration of the sale deed are already before the PCID, let the market value certificates issued by the SRO be considered.
All the
We'll
objections can
remand
be
it
taken.
back and direct them to reconsider and pass fresh order. We'll not
Definitely, my lords.
guide
Yes.
the adjudication in what manner it should have taken place.
Obliged, my lords.
It's such and such for the petition, such and such for the respondent, with the consent finally heard. This petition filed under Article 226 of the Constitution takes exception to the order dated 29th February 24, whereby his proper officer, what is the name of the authority?
Principal Commissioner.
Principal Commissioner of Income.
Respond number?
Respondent number one.
Respondent number one, my lord.
Whereby first respondent disallowed the application of petitioner filed under section 264 of IT Act seeking revision. Dot the briefly the admitted facts between the parties are that the registered the sale agreement to sale was entered into on 8/11/21, whereas property was registered, sale deed was registered on 11/3/22. 11/3/22. Dot the return was filed on 31/12/22. Dot the petitioner filed an application under section 264 on the along with annexure 2, Roman 2, issued by the SRO to confirm the SRO values prevailing as on the date of agreement and date of registration. The said revision of petitioner was rejected by assigning following reasons, para 8 and 8.1 at page 20. Next, me criticizing this finding, learned counsel for petitioner submits that para 4 of impugn order itself shows that petitioner has filed the relevant annexure 2 to establish the SRO values, SRO value. Dot the petitioner's contention, petitioner's revision was rejected mainly for twin reasons. Dot firstly, on the ground that petitioner in his return did not disclose, while filing the return of income, was aware of the rates prevailing, but did not disclose these, but did not take the benefit of the same. But secondly, in order to get advantage of reduction of in SRO values, comma, as an afterthought, application under section 264 is filed. Learned counsel for petitioner, by placing reliance on a Delhi High Court, a division bench judgment of Delhi High Court in Vijay Gupta, submits that the even error committed by an assessee can be a reason to exercise power under section 264. The power under section 264 is wide enough to take care of such mistakes. This judgment was cited before the respondent but no heed is paid to the said judgment. So far, second reason is concerned, it is submitted that the finding is perverse in nature because no material is quoted as to how a finding is recorded that petitioner's attempt is to take advantage of reduction in SRO values. No such document showing reduction in SRO values is impugn order may be interfered with. Ms. Sapna Reddy supported the impugn order and urged that the petitioner in her income did not take
Your
advantage.
Lordship, counter is 5 million. Counter is 5 million. Your Lordship,
Well, it's
consider the
interim order
counter.
is not-
Impugn order. Your petitioner supported the impugn order and urged that there is no error in the impugn order. The petitioner was given opportunity of hearing, but after following the inverted comma due process, impugn order has been passed. Next, a careful reading of impugn order shows that the twin reasons highlighted by learned counsel for the petitioner became operative reason to disallow the application under section 264 of IT Act. Next, the Delhi High Court in Vijay Gupta opined as under para 35 and 36. A plain reading of these paragraphs make it clear that even if error is committed by the assessee, it can be gone into in exercise of power conferred under section 264 of the Act, which was held to be inverted comma very wide. Considering the aforesaid, the first reason for not exercising the power under section 264 cannot sustain judicial scrutiny. Even if it is not disclosed in the return, the power under section, the revision under section 264 is entertainable. It is other aspect whether after considering the merits of the matter, the revision authority may take a different view, but it cannot decline consideration when assessee commits a mistake. Secondly, as rightly highlighted by learned counsel for petitioner, the application under section 264 was rejected by stating that application under section 264 is filed just to get advantage of reduction in SRO values. No iota of reason is mentioned as to why the annexure 2 filed by showing the SRO rates and mentioned in para 4 of impugn order was not applicable or trustworthy. No other SRO value which is held to be reduced one is also mentioned. We are convinced that both the reasons for not entertaining the application under section 264 are unjustifiable. Resultantly, impugn order dated such and such is set aside. The matter is remitted back before the said respondent. The petitioner agreed to appear before the said respondent on 2nd January. On
Well, it's 2nd January.
2nd January 25, for which no fresh notice will be required to be issued to the petitioner. The respondent number such and such shall rehear the petitioner and pass a fresh order in accordance with law. It is made clear that this court has not expressed any opinion on the merits of the case.
Obliged.
Lords, I appear for the petitioner, my lords. But
Yes,
I
ma'am.
believe these matters are coming up for filing of counters by the department.
Who appears for the Mr. Fernandez? Can we use microphone?
Representing respondent counsel, Rajita Ma'am, Lordship. Kindly have it after 2 weeks, Lordship, to counter, to file the counter.
Let them file counter, madam.
Very
2
well.
weeks
My
for
lords,
counter. 2 weeks
Very
for
well, my
rejoinder, interim relief, if any, shall remain in operation till next.
there's no interim relief, my lords. May I pray for only one indulgence, my lords? My lords, on the 22nd, if may these matters be listed on 22nd January, my lords, we'll be traveling from Bangalore, my lords, will be there physically. In fact, my lords has a matter pertaining to the same SSC on that day. Similar matters.
22nd January. 22nd January.
I'm grateful. I'm grateful.
My lord, on behalf of Dominic, sir, we are not a party in this, so our name may be deleted in these batch matters, my lord.
Name of Mr. Fernandez be deleted and replaced by such and such.
Dominic Fernandez.
Grateful, man.
Obliged.
Please.
On behalf of Mr. Vijay Punna, I wanted to file counter, so 2 weeks may be granted, my lord.
Any objection? 2 weeks time they are praying for to file counter.
My lord, may I only say this, my lord. The short
It's a
issue,
24, it's not very old matter, it's a 24 matter. Let them file counter. Let them have the satisfaction of filing counter.
Yes,
2 weeks
my
for counter, 2 weeks for rejoinder list.
may I only say this, my lord, because they have taken, this is a 6 times refund claim, my lord. So, Lordship, may I have it on 6th January, my lord, if your Lordship pleases.
No. 2 weeks. We are granting you to file rejoinder as well, Mr.
No, my
Prabhakar.
lord, I don't want to, my lord, file rejoinder.
Only 2 weeks
I'm
time
only
to file
saying,
counter list there.
my lord, let them file the counter on 6th January, my lord, if your Lordship pleases. Well, I would like to come to physical court, my lord, because they have not served me. 6th
2
January.
weeks to file counter, 6 January.
6th
Obliged.
January. I'm grateful.
Submit to the counter of Mr. Mulli Krishna. Department has to file counter.
Counter, Mr. Mulli Krishna.
Lord, I was asked to file I filed the notices issued, my lord. Your Lordship directed for.
Direction to file counter also?
Counter also, my lord, because on the last occasion, the council has raised objection regarding the maintainability of the petition because of the availability of alternative remedy. After hearing both parties, my lord, your Lordship overruled that particular objection, directed them to file counter on the merits of the case.
You know, the
order dated?
On the last occasion, my lord, I don't remember the date.
The order doesn't show that.
And granted the interim relief also.
But there is no overruling. Only proof of service and. Counter is directed to be filed,
yes.
Mr. Murli Krishna.
Your Lordship may give me 2 weeks time for filing.
2 weeks, 2 weeks for counter, 2 weeks for rejoinder list thereafter. Interim relief shall remain in operation till next.
Yes.
Well, I beg to appear in these cases, my lord. Both the cases.
You are appearing for petitioner?
67 and representing Mr. Dikshit, my lord.
Yes, who appears for the other side?
I am applied.
Yes, what?
My lord,
Counter has been
more
filed.
one submission, my lord. The short question is whether a notice preceding militation of proceedings under section 74, my lord, prior to in relation to the assessment years prior to my lord the amendment, if the issue in these writ petitions, my lords were pleased to my lord pass an order that is dated, my lord, 10th June 2024. My colleague will pass on that order, my lord. Your actually WP number 8160 of 2024.
What is under challenge before us?
Under challenge the assessment order passed by the Assistant Commissioner, my lord. My lord, without issuing notice and order passed on section 74, without a preceding notice under rule 142 1A, my lord, prior to the amendment. This is assessment year pertaining to 2018-19. Identical case, my lord. My lords were pleased to.
Have you gone through this order?
My lords, this is the matter. Your lordships may recall Based on limitation, they had taken a stay on the
No,
earlier.
no, no. I am sorry, my lord, that was wrongly tagged with that and your lordship were deleted it.
Just a minute, Learned Senior Counsel, just a minute. He has supplied this order
Yes,
and
ma'am.
says it is covered. Have you gone through this order?
No, my lords, we'll file a counter, my lords. We are giving a clarification on from when 142(1)A post the amendment, whether it is applicable in the instant case, we'll file a counter, my lords.
Mr. Senior Counsel, this is a consent order. They don't agree that's covered by this. Are you ready on merits?
Merits,
It's a
this is
consent
the only
order.
ground. This is the only ground that I have raised, my lord. That's all. I am not going dwelling into the facts, my lord, because if facts are there, I have to go before the appellate authority. Therefore, the only the
There are 4 of this order. There is a consent that it may be set aside. Therefore, we have set aside. We have not decided anything on merits. So if you are ready on merits, they have filed counter. We can hear you at an early date.
very well, my lord, very well.
Like a parties to their counsel. You don't wish to file rejoinder, Mr. Singh?
Come.
Rejoinder, they have filed counter. Do you
No,
wish?
my lords, this is coming for the first time in this issue, my lords. We'll file a counter. We seek 3 weeks time.
Counter has not yet been filed. my lord.
3 weeks time to file counter, 2 weeks for rejoinder list thereafter.
Well, the coercive measures, let them not take. Earlier, that order was continuing, my lord.
Next. Next.
May I please, Lord? Lord, notice before admission was ordered, there is an interim stay in my favor. That matter relating to this Srisailam Devasthanam, my lord, the district consumer forum.
There is already an interim relief.
Yes.
You have filed counter. You are appearing for madam.
For civil supplies, my lordships. For civil supplies, my lordship, for consumer.
And order is passed by the consumer.
Yes, my lord. Entertain the consumer dispute, my lord.
Who is
Even
the
the
answering respondent?
my lord, first and second, both are valid.
You are not appearing for them.
We are appealing only for consumer affairs and civil supplies, my lordship.
First and second, you are
First,
appearing on.
yes, my lordship.
You wish to file counter.
Not required, my lordships. We are formal party in this.
Then first respondent has to file, my lord, counter.
Your order is under. You are not appearing for first respondent.
No, my lordships.
Like a such and such for the petitioner, MS such and such for second
We are
respondent.
appealing only for R2, my lordships.
R2 submit that R2 is a formal party and no counter is required. R1 may file its counter within 4 weeks, rejoinder within 2 weeks, list thereafter. IR shall remain in operation till next day.
Much obliged.
This is the same matter where Andhra Pradesh High Court
Yes,
protected
yes,
and
yes, my lord. Yes, my lord.
yes.
Pleasure.
My lord, this is coming for instruction, my lord. Unsigned order.
It is unsigned, my lords.
It is unsigned.
It will go with the batch, my lords.
11
2110.
2110
1.
2110 of 24, same interim protection.
God bless me.
This matter is coming for instructions, my lord.
My lord, we are yet to receive the instructions. It may be posted next week, my lord.
We'll keep it on Tuesday. Let them have
My lord,
instructions.
we are not enjoying any interim directions. Already the bank account got seized, my lord. Only after seizure only we got to know about the demand order. Not even a show cause notice has been
We'll
issued.
keep it on Monday, please. Take
Obliged.
instruction. Monday for instructions.
Obliged.
My lord.
May I please, my lord? Till then, no adjustment from the bank account.
We'll hear them and then decide. Your whole case is based on a fact whether you were served with a notice or not.
Yes, my lord.
Let them have instructions on that.
Let them not take any cover, so.
We'll consider on Monday.
Obliged.
Yes.
My lord, I am appearing, your lord. The lordship, last occasion it was for the standing for the GP to assess whether this matter is covered matter or not. The lordship has noted it. I have filed it in my.
Who appears for the government? Who appears for the government?
It is a covered matter, your lordship.
Lordship, for the respondent number 2 and 4, 4 to 6.
Have you examined the previous order? We have said that you examine whether it is similar to 15890.
Even it is now the 15890 was subject to this AP High Court order, your lordship. This
Have you
was
examined that?
Yes, Lordship, actually, we have given the concerned department who is responsible for the compliance of the GST, Lordship. They have given us
Mr. Counsel, they are relying on a High Court judgment saying our case is covered. We directed you to examine them and address us. Have you examined that?
Lordship, we need 1 week time, Lordship. Because we have to get clear instructions whether there is any contrary contentions are there or not.
Lord, it is subject to the writ petition in the AP High Court. Your Lordship has directed. For a moment, Your Lordship may see the order. It was allowed in the favor of the petitioner's favor.
What is the relevance of this judgment?
Because Your Lordship has relied on this writ petition. In order to maintain parity, Your Lordship have given the order in that WP 15890 of 2024, page number 154 of mine.
15890 is based on this.
Yes, yes.
Then what happened?
Nothing. That writ petition has been allowed.
They want 1 more week's time to examine that. Legal parties to their counsel. Shri, your name please.
I will record my
Such and such praised for and granted 7 days time as a last indulgence to comply with court order dated 9/12/24, list in the first week of January.
In serial, I appear for the petitioner, my lords, in serial number 80.
Yes.
Lords, this is a case where, my lords, the show cause notices, order in original as well as order in appeal, all are unsigned. And therefore, lordship, it is covered by lordship several orders. My colleague will hand over those orders to lordship.
It is for instructions, my lords. I have received the instructions. It is unsigned, my lords. It will go with 2110.
We will give you interim protection, Mr. Counsel.
Yes, ma'am. Yes,
Shri Paranch Peshi such and such with WP 21101 of 24, same protection.
Obligements.
May I please, Lordships. My Lord, the present writ petition is being filed questioning the order in original possible first respondent. My Lord, invoking section 74 instead of 73. My Lord, nothing is.
What is under challenge? What is under challenge, Mr. Pasha?
Order in original, my Lord.
P1.
Yes, my Lord. P1.
It's an appealable order.
No, my Lord. On 2 grounds, my Lord. The one is the multiple orders, even 1718 barred by limitation, even if it is extended period of limitation, if it is taken into consideration. 1718, 1819, 1920. 3 years they have, composite order has been passed. Number one.
We have kept some matter on Monday, na? Similar matter of somebody's.
Yes, my lord.
Yes. The another point, my Lord, now just notice in 142 2A, they have not issued the notice as required.
Let them seek instructions. We have kept similar matters on Monday.
Bank attachment is there, my Lord.
We will keep it on, consider on Monday, Mr. Pasha.
My Lord. Last week to today, already bank attachment and any time they can take, my Lord. Till then, production may be given, my Lord.
No, how much is the amount determined against you?
My Lord, 21 lakhs, my Lord.
So, minus, beyond 21 lakh, they can operate their account.
21 lakhs is the tax and penalty, 25 lakhs, my Lord. Page number 77.
Your interest is protected if,
Or at least if on Thursday, my lord, I'll require instructions on this point.
okay, Shri Basha for the petitioner, counsel for respondent, praised for and granted last time to seek instructions, list day after tomorrow.
But in similar order, 85, 87.
Thursday, let him have the satisfaction of all.
Obliged. Please let them, my Lord, because already attached, my Lord, bank not to be encashed. Please let them.
You feel detached only for 1 day. We'll consider your attachment on Thursday. Yes.
It's the matter where a notification is challenged on account of the fact that the section says that the mode of determination must be prescribed by way of rules and not by notification. On the last occasion, my lords had directed me to file a chart, my lords, showing a comparison of the sections.
Which is the impugned order?
That's the impugned order is at Exhibit P2. substantial portion of the demand, my lords, arises out of a more.
If I may request for Thursday, my lord, senior is not available today. Just request for Thursday, my lord.
Thursday. Very well. Thursday. On the request of revenue, Thursday.
Obliged, my lord, deeply obliged.
This coming up a final hearing, my lord.
Yes, who appears for the other side?
And for the government, my lord, there is also university in this, my lord.
Are you ready for hearing today?
Yes.
You are ready. And who is the other counsel? Who is the other
Andhra
counsel?
Pradesh is also there, my lord. Andhra Pradesh.
My lord, state of Andhra Pradesh, my lord, the council, GP for Andhra Pradesh has to appear, my lord.
You ask whether he is ready, both of Andhra Pradesh.
It's not in the list, my lord. Pardon me, my lord, my name is not printed. I'm not aware.
The state of AP is an
Yes, party response.
party.
Yes.
Will reflect the name. Who is the standing counsel?
B. Rajeshwar Reddy.
Okay, let this matter be listed in the first week of January by reflecting the name of Shri P. Rajeshwar Reddy, counsel for AP in the cause list. You prepare synopsis, na? And remove from the head of dismissal.
Nice.
My lord, I am appearing for the petitioner.
Anybody for petitioner? Yes.
My lord, I am appearing for the petitioner.
Yes, you are ready, Mr.
Yes, my lord, I am ready, my lord.
What is the matter about?
My lord, this matter is, my lord, challenging the order, my lord, issued by the Income Tax Department pertaining to an assessment year, my lord, which may not be applicable to me is my case, my lord, because the petitioner, my lord, is a successful resolution applicant of the function, my lord. Under 19%, my lord, before it.
We'll request you to repeat. Your voice is not clear. There is some technical glitch.
Apologies, my lord. My lord, kindly see page number 17, my lord. Page number 17 is an order, my lord.
What is under challenge before us? Which order is under challenge?
This page number 17, my lord, order issued under section 148A of Income Tax Act. It is at page number 17.
And what is the nature of interim protection you are enjoying?
To take any step.
What is the error in P2?
As a
Mr. God, there's a technical glitch. Your voice is cracked. Can you come in person tomorrow or any day? Your voice is not very clear.
Tomorrow I'll be present. I'll be present. Tomorrow I'll be present before your physical.
We'll keep it tomorrow, Mr. Krishna. There's some technical glitch. We're not getting his voice. Let me read this tomorrow. IR shall remain in operation till next year.
Much obliged.
This matter be also removed, madam, from the head of dismissal.
My lord, it's of a petition with regard to the petitioner's side. With regard to the commercial tax, they took the check post.
Which order is under challenge?
Yes, sir.
Which order is under challenge before us?
Yes. And they did pay the rent 1 point, my lord.
Which is the impugned order before us?
My lords, this is to recover rent dues, my lords. This is not against any impugned order, my lords.
What is the prayer in your petition?
This is to recover rent.
No, not even the recover of rent, my lord, challenging the order of challenging that commercial tax department because they are paying for some other step check post the amount of more than this one.
Let us see, what is the prayer in your petition? Prayer is at page?
Yes. The paid is that, my lordship, that not even to pay the rent, but also to enhance the rent, my lordship.
Where is the prayer clause of your petition?
Page number 12, my lords.
Paragraph 7. Paragraph 7.
Yes.
Yes, kindly read it. What is the prayer? Let us see.
It is prayed that the Honorable High Court may please to issue a writ or direction of an order with particularly nature of writ of mandamus declaring the action of the respondent number 2 to 5 not paying the rents due approximately, along with the interest 15 lakhs for the years 2016 to 18 to the petitioner in respect of checkpost BCP Zairabad, BCP Chiragpalli, the lands of the petitioner measuring 1,000 square yards in survey number 282, situated at National Highway number 65. Satwar village and Gram Panchayat Zairabad Mandal Sangareddy district and measuring about 760
Who is liable to pay rent as per your contention?
Commercial tax department, they had to pay the commissioner.
How writ petition is maintainable? You have a remedy under the civil law to recover rent.
Not even to recover the rent, my lord. We are challenging about they have not enhanced the rent also, because for some others they have been having about more rent or more than 4 times the rent what they are paying for us, my lordship.
But that rent must have been paid pursuant to some agreement.
Yes,
containing
agreement.
those clauses.
The agreement is there at the same time, and the second
How
year.
this can be done in a writ petition? There's no public law element involved in it. This is purely an agreement based on an agreement of rent.
Yes.
You have a remedy under the civil law.
No, we can go for the civil law, my lordship, but because since there is no, even though the budget has been sanctioned, but even then they are taking it back, my lordship.
First argue on maintainability, how your writ petition can be entertained for granting you rent.
To give the direction, my lordship, for the sake of justice. Because they are not even giving us properly, my lordship. From since 6 years we are waiting for that one, my lordship. Not even for 1 day or 2
Tell
days.
us how it is maintained. There is no public law element involved. It is a agreement between you and the tenant.
But they are not respecting that agreement, my lordship. That's the reason why we have came to this court.
Have you examined the scope, ambit and scope of writ jurisdiction? You have a remedy under the civil law for execution of agreement or recovery of rent, enhancement of rent, everything. You withdraw it, go before the appropriate remedy. You have a remedy, you are not remediless.
Yes, my lordship. But the thing is that we are challenging about the proceedings also, because they have given us only about minimum rent. They are challenging only for the minimum rent, my lordship. For others, they are giving us the more rent when compared to us.
You withdraw it, file before appropriate remedy. The recovery of rent can't be gone into in a writ petition.
It's okay.
You want to withdraw?
Yeah.
Okay, Shri such and such seeks to withdraw this petition with the liberty to avail the appropriate remedy under the civil law. The other side has no objection. Petition is dismissed as withdrawn with the liberty prayed for.
Lord, in fact, my lord, this matter is coming up for filing of counter, but last occasion, my lord, your lordship has directed them to serve an amendment petition on me. I'm not sure, my lord, on whom it is served, but it is not given over to me, my lord. Because I need to
They have
put.
served it on last occasion, lordships.
You have not received amended petition.
No, my lord.
Supply him or a copy, he'll keep it in the next week. We can let IA, copy of IA 1/24 is supplied to Ms. Sapna Reddy by tomorrow, list in the next week.
Obliged. My lord, I request time for filing reply, my lord, your lordship may grant 3 weeks time, my lord, for the
Any
petition.
objection? No, 3 weeks time to file rejoinder list thereafter.
Obliged.
Thirty-seven, none for the petitioner, and even in the passover round, adjourned for 4 weeks, list under caption for dismissal.
This matter, Ms. Mamta requested for tomorrow, my lord, because Counter is filed, I believe, my lord.
None for the petitioner. No, petitioner didn't appear in the first round also. 48, 49, same, 4 weeks under caption for dismissal.
But my lord, it appears that the interim orders which she has given an undertaking, my lord, that shall not be
We are not
continued.
extending, we are not saying anything.
Obliged. Obliged.
Lords, I beg to appear in this matter.
Yes, Mr. Sandhi, how much time you will take?
I will take about half an hour at the most, my lords, for my rejoinder.
Your homeopathy undertaking is still there?
It stands, my lords.
Yes.
Unlike the state, my lords, I cannot renege.
Pardon?
Unlike the state, my lords, I cannot renege from directions of this honorable court.
Please continue.
Please, my lords, I'm
Mr.
grateful.
Sandhi, just remind us about your WP number.
Yes, my lords. 23775 of 2024, my lords.
Yes.
Item 90, though your lordships are using the papers in 89.
Yes.
Grateful. Lords, one of the key responses that my learned friends for the respondents, my lords, have made is the reliance on the judgment of the Supreme Court in Ashok Kumar's case.
Yes.
To argue, my lords, that by having participated, written the examination, we are now stopped
Yes.
from raising this challenge. Now, my lord, in Ashok Kumar, the Honorable Supreme Court has in fact, at para 15,
Yes.
relied on an earlier judgment of the Supreme Court in Manish Kumar Shahi's case
Yes.
and laid down a principle. Now, this judgment, my lords, has been duly considered at least twice by the Honorable Supreme Court subsequently. One, of course, my lords, is the oft-cited judgment in Major Meeta Sahai, where at para 15 onwards, if your lordships permit me to read.
Kindly give the citation. Is it part of your compilation?
Yes, my lords. Page 313 of the judgment compilation. 2019, 20 SCC, page 17.
Yes.
Kindly come to para 15, lords. At 321.
Yes.
Preliminary issue. Furthermore, before beginning analysis of the legal issues involved, it is necessary to first address the preliminary issue. The maintainability of the very challenge by the appellant has been questioned on the ground that she, having partaken in the selection process, cannot later challenge it due to mere failure in selection. The counsel for respondents relied upon a catenary of decisions of this court to substantiate his objection. It is well settled that the principle of estoppel prevents a candidate from challenging the selection process after having failed in it, as iterated by this court in a plethora of judgments, including Manish Kumar Shahi, my lords, which is relied in Ashok Kumar, observing as follows. Then, my lords, para 16 of Shahi is extracted. Now, my lords, please come over the page. The underlying objective of this principle is to prevent candidates from trying another shot at consideration and to avoid an impasse wherein every disgruntled candidate, having failed the selection, challenges it in the hope of getting a second chance. However, kindly mark para 17. We must differentiate this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules, as is the case here, and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and impermissible. In fact, notes kindly also mark this. A candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless he or she participates in the selection process. So, my lords, participating is not accepting the illegality. The principle that my friends are arguing is more, my lords, for example, if there is bias alleged against a particular examiner and one is aware of that disqualification, chooses to appear before that examiner, then he or she may be stopped. But when it comes, my lords, to a question of illegality in, my lords, the manner in which the process has been conducted, then, my lords, locus in fact follows only when a candidate, my lords, participates and he or she is not stopped. And this judgment, my lords, as I submitted, considers Shahi, which was referred in Ashok Kumar's case. And incidentally, my lords, after Major Meeta Sahai, the Honorable Supreme Court has quite recently, in a judgment in Abhimeet Sinha, page 327 of your lordship's compilation, had a recent occasion, my lords, to once over consider this question. This is 2024 7 SCC 262. Please come to para 35, my lords, at 347. Maintainability.
Yes. Maintainability.
Yes, my lords, maintainability. At the outset, it is apposite to address the issue of maintainability of the writ petition. It is argued by Mr. So-and-so, learned counsel, that having participated in the recruitment process, the writ petitioners, having not succeeded, cannot turn around and challenge the recruitment process or the virus of the rules. It is submitted that all candidates knew about the prescription of minimum marks for viva voce well before the selection process commenced, and the principle of estoppel will operate against the unsuccessful challengers. On the other hand, the learned counsel representing the writ petitioners argued that the principle of estoppel will have no application when there are glaring illegalities in the selection process. Further, estoppel is not applicable when arbitrariness affects fundamental rights under Article 14 and 16 of the Constitution of India. As argued by the learned counsel for the High Courts, the legal position is that after participating in the recruitment process, the unsuccessful candidates cannot turn around and challenge the process. However, it is also settled that the principle of estoppel cannot override the law. Such legal principle was reiterated by the Supreme Court in Meeta Sahai, wherein it was observed as under para 17, which your lordships have presently seen. Guided by the above ratio, in matters like this, to non-suit the writ petitioners at the threshold would be hardly reasonable, particularly when the alleged deficiencies in the process could be gauged only by participation in the selection process. And my lords, this principle at para 35, that my lords, law trumps estoppel, is too well settled. The Article 14 element, if my lords kindly recall my earlier submissions, I had sought to respectfully contend that there is in fact, my lords, patent arbitrariness in this case. And that was because of the threefold violation on their part in, my lords, disregarding the orders of this Honorable Court, in wrongly bringing in Badawat's case, and the manner in which the reservation process 1:50 allocation, etc., was violated. That is manifest from the record. Now, my lords, in this regard, my learned friends have, maybe advisedly, not touched upon the submissions on our side that this particular action of theirs is in, on the face of it, is in violation of the directions passed earlier, my lords, by the learned single judge and confirmed by the division bench. The directions are in rem. Once those directions are in rem, to bring in a principle of estoppel, my lords, to try and non-suit a writ petitioner would not lie. And the only justification that has been sought to be provided is, my lords, the fact that the web note issued by the PSC cancelling the earlier recruitment was subject matter of challenge in another writ petition. My lords, first and foremost, those two proceedings did not decide the correctness of the decision. That would be very important. The order of the learned single judge dismissing, my lords, that collateral petition was on the ground of laches. There was a contention there as regards 14 questions being erroneous. There was also a challenge, my lords, to the pre-notification at page 27 of the judgment provided by my learned friends for the respondents, my lords, in WP 21239 of 24, where the web note of 19/2/24, my lords, was impugned. Please see page 27. I hope that is before your lordships. My lords may just mark the page, my lords. I will give your lordships a written note.
Yes.
Please, my lord, just kindly mark page 27 of that order.
Yes.
Which holds, if the petitioners are really aggrieved by the cancellation of notification 4 of 22, dated 26/4/22 through web note dated 19/2/24, they ought to have approached this court and challenged the same at the earliest point of time. Though the delay on the part of the petitioners appears to be only 6 months, but in a matter of this nature, the day-to-day delay matters, and further the petitioners failed to explain even a single reason for the delay in approaching this court. Therefore, on this ground alone, this court is not inclined to entertain WP so-and-so without adverting to the other grounds raised therein. So, my lords, a dismissal on laches is not a certificate to the PSC to violate a direction of this honorable court. My lords, I grant that we have not challenged this cancellation, but the conduct, and your lordships, as I submitted, my lords, in 226 read with 215, the conduct of the respondent in disregarding a direction of this clear direction. Lordships will recall one cancellation because of some...
You already argued reconduct. The argument is based on the direction of reconduct.
Reconduct.
Yes.
And that, my lords, that there is not an iota of material to make good why the orders of this honorable court were not adhered to. Neither in the web note is there a reference, and nor, my lords, in this order that my friends place heavy reliance, is there any adjudication or determination made. And that goes to the root of the matter.
Yes.
That, my lords, is in rem. Now, my lords, as regards the process itself that the respondents have deployed, my lords had put me a pointed question as to how this current process would be prejudicial. And I think I was not able to suitably articulate it earlier, my lords. Please permit me to clarify. With the present methodology that the respondents have used, they are basically, my lords, on a misreading of Badawat's case, going by 563 into 50. What they should have done is gone by 209 into 50 for the general merit and respectively for the various other categories. Now, why, my lords, this 563 into 50 could be prejudicial or adverse to our rights is that when you take 563 into 50, there are far more number of candidates, my lords, who would apply. As a result, there is a far greater chance, and I have prepared an illustration which I will place. There is a far greater chance that non-BC candidates having higher marks will fill these 209 posts. As a result, my lords, the meritorious BC candidates will be confined to the BC list, thereby reducing the chance of other BC candidates, my lords, to be recruited in the process. Whereas, if it was done at 209 into 50, a high ranking or a a BC candidate with high marks would have a far greater chance to be absorbed, my lords, in the general category. And this is not, my lords, rocket science for the state. This is in fact your lordship's view. What my lords laid down in Kishore Chaudhary, approved by the Honorable Supreme Court in Dipender Yadav, is the law. That it has to be done, my lords, category-wise. If I may,
that was precisely Mr. Madan Mohan raised, that it should be compartment-wise, category multiplied by 50.
Yes, my lords.
Yes, yes. That has been reiterated. Yes.
I'm grateful, my lords. I'm only hoping, my lords, that this illustration would in fact make it clear. It's not just technically that we are arguing it should be category-wise. The effect has to be same. That a BC candidate, supposing a BC candidate who meets slightly lower than the cutoff in the, or is close to the cutoff of the GM, he may be the highest ranking, my lords, in the BC category. But because there are far more numbers, that is 563 into 50, who are contesting, the higher ranking non-BC candidates will edge him out. He will get pushed into BC, and all other lower ranking BC candidates by default will be excluded from the process. It is exactly to avoid that my Lord Justice Paul's judgment, my lords, in fact, in Kishore Chaudhary has very eloquently dealt with it, which I had read to your lordships again, my lords. It is in my lord's compilation at page 390, para 33. Lordships have already marked that when I had argued, my lords. I'll page. I'll just tell your lordships.
That is at page number
35, my lords, of the judgment compilation. Yes, yes. Where my lords at para 33 had looked at the constitutionality of Rule 4.3d,
yes,
refer to the law in Indira Sani at para 34, my lords.
Yes.
That reserved candidates have the right to be treated as open competition candidates. And followed, my lord, Saurav Yadav.
In fact, Mr. Sondhi, all this has been argued in great length in the
Very
first
well.
round. What we expect that in rejoinder you will deal with those bullet salient features which have come for the first time for the by the others.
I'm fully conscious, my lords. I'll stop here by saying that your lordship's view in Kishore Chaudhary has been, my lords, affirmed in Dipender Yadav's case.
Yes.
Which in turn refers, my lords, to refers to Saurav Yadav's case. And there, I won't, my lords, read those paras again, except to say that at para 30, para 30 to 32 of Dipender Yadav, the position is very clear, my lord, that the adjustment shall be only at the time of final selection. So in other words, my lords, separate merit lists are to be prepared. It cannot be done en masse as the state has sought. And if your lordship see the web note, the position becomes even more, my lords, arbitrary. There are cases where the ratio, my lords, has gone up to 1:215. I will be requesting my colleague, my lords, to give your lordships the table. We have compiled it. This is based on the web note. The web note is at page 55 of our rejoinder. 55 and 56 of our rejoinder. And just for example, for the EWS category, my lords find the number of candidates qualified, that is serial number 2, is 2774. What this web note, my lords, I do not know deliberately or otherwise, what it withholds is that the total number of posts, and that's our table, is 49. 49 into 50 is 2450. What they have done is 2774. So the ratio there goes up to 1:57. And in another category, that is BCD, I'm just giving your lordships an illustration. BCD, the figure is mentioned, my lords, at 6324. What this web note of the Telangana Public Service Commission does not say is that the total number of posts were 22. 22 at 1:50 is 1100. They have, my lords, called 6324. The ratio jumps to 1:290. So this, my lords, this material demonstrates the arbitrariness in the process. That process I can only, my lords, challenge before your lordships if I have participated. So the ground raised by my friends on estoppel also does not lie.
Yes.
And lastly, my lords, this exercise that has been done violates GOMS 55 and does not even meet the standards of Baloji Badawat. The sheet anchor of my learned friend's case, my lords, if I have been instructed properly, was that Badawat's case justified GOMS 29. Badawat, your lordships have seen, and I will, my lords, not go back to that, except to say that Badawat, my lords, was in force when GOMS 55 was issued. Badawat does not lay down any principle, my lords, which can be held to override the entire catena of case law from Saurav Yadav to Dipender Yadav to Shobana, all of which have clearly said that separate merit lists have to be made and the allocation takes place, my lords, at the final stage, which gives a right to the BC candidates to have a chance to be absorbed basis on their merit in the general category if they have done well enough. Any other process would violate their right, because then it opens up far more indefinite candidates, my lords, to enter the fray. Secondly, what the web note shows is that even Badawat has not been adhered. In the GOMS, they have referred to Badawat, my lords, to create a justification. But the manner in which the process has been worked is not as per Badawat. All that Badawat said, as your lordships remember, is that watertight silos or compartments should not be allowed. Because if it is watertight, then there can be no, my lords, migration. That's all. So therefore, my lords, the reliance upon Badawat also is really a smoke screen to try and, my lords, distract from the real issue, which is that the PSC was directed by this Honorable Court, my lords, to reconduct. At that stage, certain vested rights were created. They could not have changed the rules or the eligibility, or for that matter, my lords, conducted a fresh round of examination at all. That conduct is contumacious.
That's all, Mr. Sonkar.
That's, lords, I think that would suffice. Everything else I will give your lordships in a short written note. I'm so deeply obliged.
Does anybody else wants to add on behalf?
My lords, I'm representing J. Sudhir, my lords. Senior is on the way, my lords. Kindly take it up at 2:15, my lords.
Anybody else wants to add on behalf of the petitioner? The other day, some person, petitioner in person was also present. Yes, you can add.
May I express my gratitude, my lords, for a very patient hearing.
Thank you, Mr. Sodhi.
Grateful.
WP number, please tell your WP number.
32978.
WP
32978.
978.
Yes, sir.
Of 24.
Yes, sir.
May we know your name?
Suripalli Srinivas.
Mr. Srinivas, please don't. don't repeat. No? You must have heard what has been argued for last few days.
Yes, sir.
Please don't repeat it. We are ready to hear you, but please don't repeat the same argument. If you want to add something, we are ready to hear you.
Sir.
Yes.
Sir, basically this GO is in the nature of a communal GO, in the sense that marginal communities are restricted to their lot in 1:50 ratio, as the data has already been sent to you, sir. SC category, it is 1:52, whereas ST, it is 1:53. Whereas for BCB, it is 204, and BCD, it is 287. So the proportionality justice has been highly skewed in favor of one and in disfavor of some others. This has been specifically mentioned by the then commission in their counter. So they said some of the communities will be overrepresented while others will be either low represented